This is a Power 98.7 podcast. Now we're talking. Subscribe to Power 98.7 podcasts in iTunes or wherever you get your podcasts. There's more on power987.co.za.
Okay, let's stay with that discussion. And the Democratic Alliance have said that the public protector Busisiwe Mkhwebane has a poor understanding of the law. This comes after she said, of course, yesterday that the rules adopted by the National Assembly in December last year for the removal of a head of a Chapter 9 institution are unconstitutional and unlawful. Let's speak to the DA's Chief Whip, Natasha Mazzone, who joins us on the line. Good afternoon, and thank you very much for your time.
Good afternoon, and thank you for having me.
Why do you believe that the public advocate Mkhwebane is getting it wrong in this case?
Well, I think the reality of the situation is that Advocate Mkhwebane has never enjoyed having her conduct scrutinized, and she will fight tooth and nail to avoid being held accountable. I think that this particular statement that she's made declaring Parliament to be unconstitutional in their action only goes to serve how poor her understanding of the law is and how correct the DA is to have her asked to have her removed. I think she simply does not understand that although the Chapter 9 institutions are independent, they are not above scrutiny or above criticism. And as the Democratic Alliance and as Parliament, part of our job and our constitutional mandate is of oversight and to hold people to account. And that is exactly what we're doing via this particular motion. And Section 194 of the Constitution has always been there. It's always existed. What was lacking was the fact that there were no rules of Parliament to guide how members of Parliament as to how you enact 194.
She makes the argument, and I do wonder whether she does not have a case, it's just in terms of the laws of natural justice, that people who are likely going to stand in judgment of her or decide her fate or her future as the public protector could be people who are deeply conflicted, either because they have had adverse findings made about them by the public protector, or alternatively have made pronouncements in the public sphere that are, against the public, against Advocate Mkhwebane.
You see, that's, again, it goes to a question of understanding the law and understanding the role of Parliament and parliamentarians. Now, MPs, it's no hidden secret that the Democratic Alliance voted against the appointment of Mkhwebane when she became public protector. But here's the thing. Mkhwebane cannot have a say in who in Parliament, the very body that has the operational function to have oversight over her body. She cannot have the say in who from that particular body represents Parliament on a panel. It's the fact of the matter is Parliament is made up of 400 members who are constitutionally elected and who swear an oath of office. The Committee of Parliament will be done in the open, in an open and transparent, free and fair manner. That's how Parliament operates. And, it simply goes down to an understanding of how and why Parliament has the power of accountability.
Now, that said, though, she obviously has issues with she's expressed, her objection to the rules that have been adopted, saying that they're unconstitutional. Is there a possibility, it seemed like, because she has asked that the Speaker put a halt to the process. Ultimately, I suppose that will be for the Speaker to decide, but it seems like there might well be an unprecedented challenge here to the rules adopted by Parliament by Advocate Mkhwebane. She said she could head for the courts.
I think Advocate Mkhwebane would do well to look at the real meaning and understanding of the Constitution. I think she would do well to look at the powers and privileges granted to Parliament according to the rules of the National Assembly. And I think that she would do well to come to Parliament and open herself up to scrutiny, because if in fact she has nothing to hide, there is no reason why she shouldn't want to be tested in front of the country, in front of Parliament, and prove her case for once and for all.
Now, Ultimately, though, this process that will unfold if and when it does get underway is that will result in a decision that will be taken by politicians to make a decision about whether they feel she's fit and proper or not, regardless of what arguments she may present in her own defense. Parliament could still argue to remove her. Could still vote to remove her. And the opposite is also true, that despite how weak her arguments may be in her own defense, she could still be removed, So ultimately, it doesn't really matter what the substance is of those kind of arguments that will be made, or whether people are biased one way or the other. It'll be a political decision. It is not going to be something that a decision taken on the basis of evidence and law.
Well, if you are going to take that interpretation or have that preconceived notion, then the same must be said about her appointment, because the same people who appointed her are going to be judging her character now as to whether or not she's a fit and proper person. So does that mean that when Parliament took the decision to appoint her, it was a political decision and not one based on sound clarity and knowledge of the law, what she was capable of, knowledge of her political affiliation, anything like that? So I think that argument, falls short, because it's within Parliament's right to call the head of a Chapter 9 institution before them to be held accountable.
But what I'm saying is that the expectation is that ultimately the arguments that may be presented about the rules and what the rules are saying may actually prove to be academic, because ultimately this decision will be made along party political lines.
Does that mean that her appointment was done along party political lines?
Well, now some would argue that, because in spite of what you were arguing as a DA about her suitability for the role, the ANC, together with I think the EFF and other parties, went for her and all voted along party lines.
Well, you see, that's the thing about Parliament. It goes to prove how Parliament cannot just be swayed on political opinion. It was the political opinion of the Democratic Alliance that she was unfit to hold office. And it turns out that, in our opinion, we were completely right. So, to say that it's now going to be a political decision as to whether she's fit to hold office or not, well, certainly, if political considerations were taken into account, then she would have never been appointed in the first place.
So you're denying that there were political considerations were taken into account when she was appointed?
I'm saying that, of course, there were political considerations, but I'm saying they couldn't sway whether or not she was appointed. So what you're trying to say is that no matter what the rules of the National Assembly say, regardless of anything, it's going to be a political decision at the end. And I'm saying it can never just be a political decision at the end, because it is impossible to sway the opinion of 400 people, that 400 members from different political parties will all have the same political view. So the fact of the matter is, you have to look at the rules of Parliament. You have to look at the rules of the country. You have to look at definitions of what are fit and proper. You have to look at rulings that the court has made. You have to look at past precedent in the situation. And that will determine the outcome of this particular case.
All right, we'll leave it there. That's the DA's Chief Whip, Natasha Mazzone, on the line.
You've been listening to a Power 98.7 podcast. For more podcasts, visit power987.co.za or subscribe wherever you get your podcasts.